Welcome back to the deep dive. Today we are tackling one of those really fundamental but also kind of confusing questions that you might face when dealing with the law. How much evidence is actually enough?
It's really the foundational question of liberty, isn't it? For you, listening, understanding this is so important because every single step up that evidence ladder, it corresponds to more power for the state to intervene in your life.
Right, from just a simple question all the way to, full detention.
Exactly.
We hear all these terms thrown around: suspicion, probable cause, beyond a reasonable doubt, but they feel so abstract. What do they actually mean? What percentage of certainty are we talking about?
Well, that's what's so great about the material we found. It gives us a structure, a framework of 4 specific levels of evidentiary sufficiency.
So that's our mission today. We're going to map out those 4 levels.
We should stress, though, these percentages, they're more like guidelines, not hard and fast rules. So much of it comes down to the professional discretion of the police, the prosecutors, and ultimately the judges.
And it varies case by case.
Absolutely.
Okay, so it's a sliding scale. Let's show you exactly what legal action each level allows, and maybe more importantly, what it doesn't.
Let's do it.
So let's jump in with level 1, the starting line.
Right. At this stage, we know an incident happened, but we don't know who did it.
So this is just pure suspicion.
Pure suspicion. We're talking less than 50% sufficiency. It's basically a crime might have happened and someone might be connected, but that link is, it's pretty weak.
Can you give us the practical example from the source?
Sure. So imagine some valuable items disappear from a locked room at work. The very next day, an employee who had a key, they just don't show up. Can't be reached.
Okay, that's suspicious.
It is. That person's now a suspect. But that's all they are. The evidence is purely circumstantial. It doesn't really rise to a level where you can believe they're guilty.
So if that's all you have, less than 50% certainty, what can the authorities actually do?
Only the most basic thing.
Yeah.
Issue a summons. It's a formal request for questioning.
Just a piece of paper telling them to come in and talk.
Exactly. And the key thing, the most important restraint at level 1, is that police cannot get an arrest warrant based on just that. Your liberty is protected from that level of intrusion.
And the investigation just stalls there?
The case stays open, but it gets filed as perpetrator unknown for a while, at least until the statute of limitations runs out.
Okay, so that brings us to level 2. This feels like the first big jump.
It's a huge leap. This is where we go from just suspicion to having reasonable knowledge of who the perpetrator is.
So we're crossing a threshold.
We're hitting 60% sufficiency or more, and this is the critical point, because the state can now move from just interviewing someone to formally charging them as the accused.
In a lot of places, this is what they call probable cause, right?
That's a perfect parallel. Yes.
Yeah.
We're moving from a maybe to a highly likely.
So what kind of evidence pushes a case over that 60% line? What gets you there?
Well, the source gives 3 great examples of evidence that really solidifies it. First, you have a victim who clearly identifies the suspect.
Okay. Direct identification.
Second, maybe you have CCTV footage. And not just spotty footage, continuous video that shows the person committing the actual offense.
That feels pretty solid.
It is. Or, third, the suspect gets that level 1 summons we talked about, and they just don't show up, they disappear. That suggests they're avoiding justice.
So once you hit that 60% marker, the state's power, it just ramps up.
Oh, absolutely. Now they can go to a court and request serious warrants.
Like an arrest warrant.
Arrest warrants, search warrants, even orders for temporary detention. It's also the point where other officials might freeze your assets or block bank transactions.
Okay, wait. Let's talk about detention. If you can arrest someone at 60% certainty, how does that work with the whole presumption of innocence?
That's the detention paradox. It's such a critical point.
I mean, the Constitution says you're not supposed to be treated as guilty before you're convicted.
You're right. And that principle acts as a check. It means that even with an arrest warrant, unless there's a very specific risk, like the person is a flight risk, or they might tamper with evidence, the accused should generally be released.
With or without bail.
Correct. The system has to lean towards liberty, because 60% is not 100%. It's not proof.
I see. So the 60% gets the arrest, but the presumption of innocence is what decides if you actually stay locked up.
Precisely. And the source pointed to South Korea for an interesting way to make that check even stronger.
What do they do?
Well, in their system, prosecutors have to review all the police evidence before the police can even go to a court to ask for those level 2 warrants.
It's like a mandatory second opinion.
It's an extra layer of expert scrutiny.
Yeah.
It just helps ensure the evidence is truly solid before someone's liberty is taken away. It's a really good model for thoroughness.
Okay, that brings us neatly to level 3. This is really about preparing for trial, isn't it?
It is. We're now at 70% sufficiency, maybe even higher. This is the prosecutor's main decision point. They have to decide if the case is strong enough to actually file in court.
They're aiming for a much higher level of confidence.
Approaching 100%, ideally.
But if level 2 was enough to get warrants and make an arrest, why do they need that extra 10% or more?
Because a trial is a whole different ballgame. A defense attorney is going to pick apart every little gap. So even if the police have 60%, a prosecutor will almost always order more investigation. It's like case tightening.
And what does that case tightening look like? What kind of evidence fills that gap between 60% and 70%?
It's about nailing down the details, tracing money through bank accounts, analyzing GPS data from a phone to place the suspect at the scene at the exact time.
Getting really specific to remove any doubt.
Exactly. But this is also where the real world gets messy. A prosecutor can have 70% of the physical evidence locked down, but then they have to worry about the human element.
The witnesses.
The witnesses. Are they older? Will they forget things? Are they the type to change their story under pressure? Do they move around a lot and might be hard to find for the trial? All these external factors can sink a case.
Which explains why some legal systems use other tools to get a conviction, even if it's on a lesser charge.
Right. Things like plea bargaining, which is common in the U.S., or something called nolle prosequi, which is basically a prosecutor's formal decision to drop the case.
So they trade a little bit of justice for certainty.
In a way. It guarantees an outcome and avoids the risk of a long, expensive trial where even a 70% case can fall apart.
The source also mentioned a contrast with inquisitorial systems like in Spain or Belgium.
Yes, in those systems you have what's called an investigating judge. This judge actually works with the prosecutor from the beginning to gather facts, examine evidence.
So the judicial oversight starts way earlier.
Much earlier. It makes that 70% threshold much more robust before a case ever sees the inside of a public courtroom.
And that courtroom is the final stage, level 4, case adjudication.
This is it, the highest standard. We're talking 90% sufficiency and above. It's the closest we can possibly get to what you might call perfect evidence.
And the legal standard has a famous name.
Beyond a reasonable doubt.
It's non-negotiable.
Absolutely not. In our kind of system, if the prosecution fails to meet that 90% plus standard, the only outcome is an acquittal, a not guilty verdict. The case is dismissed. The bar is set that high for a reason.
Because the consequence is the loss of someone's freedom.
Permanently, in some cases.
Okay, let's make this real. The source gave a perfect evidence checklist for an assault case. How do you actually hit that 90% mark?
It's not just one thing. It's about having multiple independent pillars of proof that all lock together perfectly.
Okay, pillar 1.
The victim's clear and consistent testimony. Pillar 2, you need continuous high-quality CCTV footage of the entire incident. No gaps.
Pillar 3 would be the physical evidence?
The weapon, yes. Recovered and linked to the crime. But you're not done.
What?
You need neutral eyewitnesses. One or two. The source warns that if a data set, especially an online one, looks too clean, too systematic, too perfectly organized, that should actually trigger an alarm.
So the lack of normal human messiness is the tell.
It could be. A data set that's suspiciously tidy might suggest it was deliberately manufactured to frame someone, rather than collected from real organic activity.
So it's not just about the evidence, but the story the evidence tells about itself.
Exactly. The lesson is that you have to assess not just the quantity of the evidence, but its structural integrity. Does it reflect the chaos of real life or the clean order of a fabricated story?
That is a brilliant point to end on. I think this deep dive into the 4 levels, suspicion, probable cause, prosecution certainty, and beyond a reasonable doubt, is just so empowering for a citizen. Knowing these levels, it lets you actually evaluate your rights and see the limits of state power in a really clear way.
And looking at the other systems, South Korea's review process, European investigating judges, it gives us all this data for how we could reform our own laws. The goal is always to better protect public liberty, and comparing systems is how we learn.
So, now that you know these percentage thresholds and the power they unlock, here is our final thought for you to chew on. How might advanced technology like AI that can analyze millions of hours of surveillance footage or hyper-precise GPS, how might that change this whole dynamic? If technology makes it easy to jump from level 1 suspicion straight to level 3 certainty, what new challenges does that create for the human discretion that's supposed to be the ultimate safeguard of our liberty?
Something to think about. Till next time.